proceed.
Thank you, Madam President. Your Excellency. May it please the Court, my name is Zach Patton on behalf of the respondent, Reverentia. With me is my co-agent, Michael Pasquay, and of counsel is Shay Sammons. I will be spending 22 minutes discussing the first two issues, and my co-agent will take 21 minutes discussing the last two. We reserve 2 minutes for serve rebuttal. First, I will discuss how Reverentia's support for the East Agnostican referendum was consistent with international law because Reverentia's actions did not intervene in Agnostica's internal or external affairs, and its actions were consistent with state practice. And then I will discuss how East Agnostica's secession from Agnostica and integration into Reverentia was lawful under international law. First, because there's no prohibition against doing so, and Agnostica's actions allowed Agrevs to exercise self-determination through remedial secession. Turning to support for the East Agnostican referendum, Reverentia's support for East Agnostica's referendum did not provide any sort of support which would have unlawfully intervened in Agnostica's internal or external affairs, because it neither violated the principle of non-intervention nor used a threat of use of force. For simplicity, I will say threat of force, which is a type of intervention, but I am separating the two for simplicity's sake. Additionally, the Reverentia's actions were consistent with state practice. There are three main events contained in the compromise I would like this court to pay attention to. The first is the Reverentian President Novalis' speech, in which he pledged Reverentian support for an independent East Agnostican state. This is contained in paragraph 34 of the compromise. The second is the Reverentian Parliament resolution titled On the Crisis in East Agnostica, which I will refer to as the Crisis Resolution. That resolution authorized the Reverentian government to recognize the results of any referendum, and that includes any diplomatic recognition of an independent East Agnostican state.
And what paragraph was that?
34, Madam President.
Thank you very much.
35, excuse me.
All right.
The third event is the deployment of Reverentian troops to Reverentia's border with Agnostica, which was done in order to maintain peace prior to the referendum, and that is on paragraph 37. Turning to the non-intervention principle, no state has the right to intervene in the internal or external affairs of another state. This is held in the Montevideo Convention, and both parties have assented to this principle by ratifying that convention. Oppenheim defines intervention as forcible or dictatorial interference by a state in another state's affairs, which is calculated to impose certain conduct on that state. Intervention is meant to compel a state to do certain action.
Who's Oppenheim?
Oppenheim was a jurist during the 20th century, Your Excellency. He's well respected, and his treatises have since been used.
He was a jurist on a court?
Let me rephrase, he was a well-renowned international scholar.
Okay. Where did he teach?
Your Excellency, Cambridge, I believe.
And
So perhaps Professor Oppenheim might be able to.
Yes, ma'am.
and why should we listen to Professor Oppenheim?
Your Excellency, Professor Oppenheim is one of the most cited sources within scholarly works within international law. This court has cited to him countless articles have cited to his treatises.
Do we have authority to utilize the works of scholars in our interpretation of international law?
Absolutely, Your Excellency. Under Article 38, 1D of this court statute, you may use the teachings of most highly qualified publicists of various nations.
Is Article 38, are the sources listed in there, listed in order of preference?
They are, Your Excellency. It begins first with international conventions, such as the United Nations Charter. Then it would be customary international law. general principles of law recognized by civilized nations, and then articles of scholars and other judicial decisions.
Thank you.
Going back to Oppenheim, or to intervention in military and paramilitary activities in and against Nicaragua case, this court found non-intervention principle is customary international law. And in that case, this court held that intervention is only prohibited if it bears in matters that only a state is free to decide. This includes the formulation of foreign policy or the choices of political, social, economic, or cultural systems.
And are you still citing the court
I
explanation?
am, Your Excellency, or Madam President. Here, referentia provided no support that would have intervened in Agnostica's internal or external affairs. Both President Nuval's speech and the crisis resolution was political rhetoric that wouldn't rise to the level of intervention. And to give you an example of political rhetoric that was not considered, or that's considered not unlawful, let me rephrase. Political rhetoric that was not unlawful intervention was a remark made by French President Charles de Gaulle when he was making an official visit to Canada. During a speech, he said, exclaimed, "Long live free Quebec." So similar here, President Nuval's speech, in he offered support to Thomas Bien, who was head of the East Agnostican Provincial Legislature and an agnostic parliamentarian.
Mr. Bien, at least by the applicant's assertion, essentially is the head of a coup. Would you agree? Yes, he has a parliamentary position, but in this context, he's leading a group against the government.
Your Excellency, is there a question in that?
So the question is, making a clear statement of supporting somebody who is essentially leading a coup is different, wouldn't you agree, from saying long live free Quebec?
Yes, Your Excellency.
Quite a bit different. You're actually supporting an active current coup rather than making a theoretical political statement, for lack of a better term.
Yes, Your Excellency.
I don't see that as a really good analog.
Well,
The Canada reference.
okay, Your Excellency. Well, even if this court were to find that Mr. Bien were behind a mastermind behind a coup, he never requested nor received any support whatsoever. So
But that's not the issue, right? The issue is not whether the person leading the coup requested the support. The issue is whether a state agent was offering support. And that's the unlawful intervention, isn't it?
well, it was a mere expression of support for independence. It was not the compromise.
But you haven't cited, other than this Canada case, which I don't think is a good analog,
I don't remember even hearing that it was a case.
or I'm sorry, right, the Canada statement. I'm not hearing you cite any judicial or academic interpretation that says that an action like what we have here, where there's an offer of direct support to somebody leading a coup, is not unlawful intervention.
Well, Your Excellency, intervention is by definition forcible or dictatorial interference. It's imposing will on another state, and by exclaiming, "We support your independence," an ambiguous statement like that is not forcible.
Can you give us some examples of what has been considered as unlawful intervention? Short of the use of weaponry.
Your Excellency, reverential cannot. Moving to the use of force, or the threat of use of force, Article 2.4 of the United Nations Charter forbids the threat or use of force against a state's territorial or political independence. A threat of force is an explicit or implicit message formulated by a decision maker and directed to the targeted audience, indicating force will be used if a rule or demand is not complied with. I would also like this court to be made aware of the report done by the Council of the European Union in its international fact-finding mission on the conflict in Georgia, in which it held that not all militarized acts amount to a demonstration of force and thus a violation of Article 2.4. Many are routine missions devoid of any hostile intent and are meaningless in the absence of a sizable dispute.
And how was that applicable to the Georgia situation?
In that case, there had been military buildup on both sides of the Russian and Georgian border. Georgia had actually invaded Georgia in South Ossetia. I am, to Reverend's knowledge right now, not entirely familiar with all the facts behind that ruling though. In 1939, Nazi Germany requested Poland agree to unify the city of Danzig with the German government. When Poland refused, Germany renounced a non-aggression agreement between the two states, and that made war implicit and imminent. Here, deploying troops did not create a threat of war, and it did not indicate force would be used if Agnostica refused to comply with any demands, mainly because Reverentian never made any demands whatsoever. The soldiers were deployed in order to provide aid to fleeing Agnorevs who were fleeing violence occurring in Agnostica, and the troops were meant to prevent any spillover violence into Reverentia. Additionally, after deployment, President Nuvalis sent Prime Minister Moritz a diplomatic note stating, and I quote, "I want to clarify that our troops have been moved to the border to offer aid to any Agnorevs fleeing the violence in East Agnostica. We have no territorial ambitions. Reverentia is deeply concerned about the state of affairs in East Agnostica, and we are worried that the violence will spill over into Reverentia." Now, Your Excellencies,
Agent, isn't this, shouldn't we look beyond just the words and look at the intent of sending troops to the border? I understand that he said you have no territorial, intentions, but I think the actions are inconsistent with that.
well, the troops were sent over during a time when there were violent crackdowns taking place in East Agnostica against ethnic Reverentians, the Agnorevs, and even such practice or actions are consistent with state practice. Currently, right now, following Russia's annexation of Crimea, both Poland announced that it was going to send additional military personnel to its border with Russia. NATO also announced it was sending additional military personnel to bolster its security forces on its borders with Russia. Additionally,
have any of those forces crossed the border?
they have not, Your Excellency.
Your forces crossed the border.
Not until after the secession, though.
Right, but if the question of secession is open for a decision. If we interpret it as being unlawful secession, then you would agree that your troops crossed an international border.
That's correct, Your Excellency.
Would you then agree that the fact that their troops crossed an international border would be a unlawful intervention? Or, I'm sorry, unlawful violation of sovereignty?
Your Excellency, can you please rephrase that? I'm sorry.
If the secession was not lawful, right, then East Agnostica was not a part of your country at the time the troops crossed into it. Is that correct?
Correct.
Okay. So if we find that the secession was unlawful, then do you agree that your country violated international law when It's just true across the border.
Yes, Your Excellency. Moving on to the next issue, though, or moving to, support for referendums are consistent with state practice, though. In 2005, prior to the Quebec referendum, former French President Jacques Chirac expressed France's willingness to recognize an independent Quebec. Similarly, similar to President Nuval's remarks, former French National Assembly President Seguy told Quebecers that France would, quote, walk by your side at the pace and in the direction you will have chosen.
And has that been examined by any international court as to whether what is or is not consistent with international law, those statements?
No, Madam President. Moving to the second issue. East Agnostica secession from Agnostica and integration into Reverentia are consistent with international law, and in any event, the effectivity principle makes retrocession inappropriate. Your Excellencies, the Agnorab's secession was lawful, first because international law does not prohibit non-forcible secession, and Agnostica's history of human rights violations culminating in the Boxing Day massacre allowed the Agnorabs to exercise self-determination. In the case of the SS Lotus, this court's predecessor, the Permanent Court of International Justice, held a state's conduct is presumed lawful unless prohibited by international law. This has become known as the Lotus Principle. No international rule prevents a political entity from within a state from seeking secession through non-forcible means. Additionally, as Professor James Crawford notes, under international law, secession is neither legal nor illegal, but rather a legally neutral act. In an advisory opinion, which I will discuss in further detail later on, the Canadian Supreme Court held that international law contains neither a right of unilateral secession nor an explicit denial of such a right.
I'm a little confused by Professor Crawford's statement. Secession is neither legal nor illegal under international law?
Yes, Your Excellency. Secession is a fact. It's a legal fact.
So why are we arguing, so this whole issue about whether the secession was lawful is meaningless? It's a fact. It's not lawful or unlawful.
Well,
Secession, anybody can secede anytime they want, and there's no legal issue for the court.
Well, Madam President, there are legal ramifications. Certainly if this court were to decide that there is no legal dispute or legal issue with the secession here, Reverentia would not argue that. However, there are international legal implications with secessions, but it is a legally neutral act.
I guess I just can't quite figure that out.
I'm confused by that as well. So, putting aside the impact of secession, what are the standards that lead to the fact of secession actually having occurred? What needs to happen for a secession to be accepted, be valid?
Your Excellency, for a secession to be valid, several different things can happen. One, which occurs here, is something known as the effectivity principle. When the Canadian Supreme Court addressed Quebec's unilateral secession,
The effectivity principle, as I understand it, correct me if I'm wrong, essentially says it's already happened, so we're not going to go back and undo it.
that's correct, Your Excellency.
That's not, that's ex post facto. That's, after the fact saying, well, you can't put everybody back, so leave it as it is. What I'm asking you is, a bunch of folks in Montana decide they want to be a separate country. What do they have to do to make that valid?
Well, Your Excellency, there are numerous different, principles or reasonings that can be used. In this instance, exercise of self-determination is what was the appropriate factor leading to or allowing for the Agnorabs to secede from Agnostica.
I'm really struggling with this. It seems like you're leading us down a very slippery slope here, and that any group of people, regardless of the validity of their grouping or, historical perspective or anything, can come together and say, we are an entity, we herefore secede from the United States of America, and there it is. They've established a country. Doesn't track for me. There's got to be something more.
Well, Your Excellency, in this case, there's been a long history of human rights violations that led to this. So in a sense, it did give justification to the secession.
I mean, take for example the Native American tribes, right? They have some historical context. They first of all, were indigenous people. Second of all, they have their own sovereignty that's been accepted by treaty. So it would make some sense if they would say, okay, as this entity that's already been accepted as a sovereign, we're seceding. But your folks, I don't see where that happened. Those facts don't exist.
Well, Your Excellency, even if this court were to find that the secession was unlawful and that the conditions weren't right, as of now, I would perhaps be a moot point under the effectivity principle because, as you said before, this is now after the fact. And looking at the effectivity principle, the secession is now fact, is now a legal fact, is now a legal reality. That
What's been the result of that? Have people moved around? I mean, what would be so hard for us to put back if we said this was a unlawful secession, East Agnostica is still a part of Agnostica, and is decreed?
Madam President, I see my time has concluded. May I briefly answer this question? Your Excellency, already 33 states and including 2 Security Council permanent member states have already recognized the new referendum borders. So you would be undoing essentially newly recognized territory. Thank you.
Madam President, Your Excellency, may it please the court. My name is Michael Pasquay. I am co-agent for Reverentia. There are 2 final issues dealing with the control and use of the natural resource that has been the discussion of today, which is marthite. The issues before this court involve a treaty ratified by both parties which provide for how this mineral is to be mined and to be sold. And it is this treaty that Reverentia relies upon in its actions taken up until this point. Reverentia addresses the issues in 2 parts. First, by showing that the Marthite Convention was valid until East Agnostica's secession in March of 2013, and of which Agnostica breached this convention prior to that secession date. Secondly, there are 2 justifications for Reverentia's removal of the software from the mining facilities, both of which are justified under international law. In order to address the first issue, it must be broken down into multiple parts. Reverentia considers the Marthite Convention to have been in effect until 1 March of 2013, at which point Agnostica breached prior to that in April through their unlawful repudiation. Secondly, the convention terminated after Reverentia's integration of the seceded territory containing the Marthite facilities in East Agnostica. To demonstrate Reverentia's compliance with the Marthite Convention, Reverentia submits that all actions taken were done in good faith and without contravening the object and purpose of the convention. A basic principle of international law lies underneath the term pacta sunt servanta, which provides that treaties are binding upon the parties and must be performed in good faith. This is in the Vienna Convention of the Law of Treaties at Article 26, which while both parties are, or both states are party to, does not affect treaties which were in effect before the signing of the convention. And that is the case here. However, Gapsikovo-Nagimeros at paragraph 142, this court has shown that the theory of pacta sunt servanta is one that it wishes to hold. Reverentia has abided.
Wishes to hold? A court, we just decide what we want to hold and what we don't want to hold?
Madam President, I apologize for my use of words there. It is a theory that this court has used in the past in deciding cases.
A theory, that's all it is? It's a theory and we've decided cases on that basis?
It is a basis of customary international law, Madam President.
So out, regardless of the time limit on the Vienna Convention on Law Treaties, you're saying it applies?
Your Excellency, yes, it would apply, simply using the Vienna Convention of the Law of Treaties as an example of the definitions which have been agreed to by both parties later and which have been held as customary international law by this court prior to them, thereby making them applicable to the case at hand. Reverentia has abided by this principle through not prohibiting sales of marthite to the traditional Reverentian users while it did sell the marthite for commercial purposes. And this is through Article 4D of the Marthite Convention, which while providing for the traditional users to obtain marthite, also allows for Reverentia to sell to commercial users if certain conditions are met. It wasn't until after the marthite was found to be beneficial to the treatment of childhood autoimmune diseases that Reverentia then sold the marthite in addition to the traditional users to the outside pharmaceutical companies. It was indeed Agnostica who, after repudiating the treaty, decided to sell marthite solely for pharmaceutical purposes and by their own law prevented any marthite from entering into Reverentia or being allowed into any hands of agnosticans who were not in receipt of a government permit.
Would there be enough at the current levels that Reverentia wants to sell marthite? Would there still be enough left over for the historical medicinal purposes in the African country?
Your Excellency, if I am understanding your question correctly, can Agnostica provide for their commercial use and the traditional use?
Correct.
The compromis is silent as to if that would be possible or not, and I would not choose to speculate on that matter.
Thank you.
With these facts that I've laid out, Reverentia contends that it operated in good faith within the convention by following the terms of the convention. In addition to good faith, both parties to a treaty, or all parties to a treaty, must abide by the object and purpose of the treaty. The object and purpose of the Marthite Convention does not limit Reverentia from selling marthite commercially. Reverentia did not violate the object and purpose of the Marthite Convention because the object and purpose cannot be violated when a party acts in accordance with the clear text of a treaty's terms.
What is the object and purpose, would you say, of the Marthite Convention?
Madam President, the object and purpose of the Marthite Convention in Reverentia's eyes is one to provide for traditional users as well as for commercial uses if a party so sees fit and falling within the terms within that convention. Reverentia takes that view based on this court's ruling that while a treaty's object and purpose is commonly interpreted from its preamble, it should not be read alone to obtain this fact, and the entire treaty must be taken into account. In the arbitral award of 31 July 1989, this court held at paragraph 56, where a preamble laid out the desire to reach a settlement in that case, the consent on how that was to be achieved was laid out in a defined article. And Reverentia Reverentia contends that Article 4 is the further explanation of the preamble of the Marthyite Convention. Because this treaty contained that provision broadening the entire scope of the object and purpose, Reverentia has followed the terms of the convention that are clearly dictated and therefore has not contravened the object and purpose.
I'm sorry, before you go on, can you just tell me again, what case was it that in which we opined about the, now I forget exactly what you said, but the object and purpose, what you just last said, whether the object and purpose comes from the preamble or not.
Madam President, two cases. The one of which I directly cited to you was the Arbitral Award of 31 July 1989 at
And what did that involve?
That involved a dispute between Guinea-Bissau and Senegal as to dispute or settlement of a dispute within a treaty. And in that case, the preamble laid out a desire to reach a settlement if a dispute were to arise, but the treaty's terms itself laid out how exactly that was to occur. And Reverentia submits that in this case is similar, where the preamble provides a broad overview of what the treaty is to provide, the articles within further define that.
Thank you.
Thus, Reverentia has continued to operate in good faith, while it is Agnostica who has not, and through the illegal repudiation of the convention, Agnostica has materially breached what Reverentia has relied upon since 1938, which was the signing and ratification of the Marthyite Convention. Agnostica's April 2012 repudiation was not justified under international law. The Vienna Convention on the Law of Treaties at Article 60 provides that a material breach of a treaty is either a repudiation not sanctioned within that convention or a violation of a provision essential to the accomplishment of the object and purpose of the treaty. And this court has held the same in the Gabskova-Nagameros project at paragraph 46.
Yes. Recognize the same, what do you mean by that?
Madam President, allow me to clarify, has held that either a repudiation that's allowed within the Vienna Convention on the Law of Treaties or a violation of a provision which is essential to that current treaty which the two parties are operating under to successfully be continued, that violation would be a material breach.
And the Vienna Convention on Law of Treaties is applicable in this case?
Madam President, again, while both parties are signatories and ratified that convention, Reverentia relies on this court's ruling in Gabskovo project or Nagameros project at paragraph 46 that that theory is customary international law.
That article, a particular provision?